Welcome to Georgia Court News. We're going to be summarizing the case today, the case of Christopher Dubberly. Mr. Dubberly is convicted out of Tattnall County, Georgia, and Mr. Dubberly is convicted of 7 separate counts of sexual offenses against an 8-year-old child. I cannot imagine any worse set of circumstances than for a man to be charged with sexual offenses against an 8-year-old child. An innocent man charged and convicted with sexual offenses against an 8-year-old child. We're going to show you he's innocent in this summary. Mr. Dubberly's case, he was represented by Jonathan Gaskin out of Hinesville, Georgia. He was prosecuted by Sandra Dutton, Assistant District Attorney, Atlanta Judicial Circuit, Hinesville, Georgia. The judge in the case was the Honorable Charles P. Rose, Jr. of the Superior Court of Tattnall County. All right. Mr. Dubberly went to court, and for whatever reason, he decided to enter a guilty plea. We're not going to get into those reasons today. We will get into those reasons at a later podcast. Today, I just want to get your attention to this case, and I'm not going to have any problem doing that. First, I want to explain. When you enter a guilty plea, the judge is required to get a factual basis for a guilty plea. Uniform Superior Court Rule 33.9 requires that a factual basis be recorded on the record for the guilty plea. And it goes a step farther than that. It incorporated with the Uniform Superior Court Rule 33.9, in order for a plea to be knowing and voluntary, the elements of the crime must be explained on the record to the criminal defendant. Now, I've read this transcript, and I don't see where these elements of the crimes were explained to this criminal defendant nowhere at this hearing. It's required to be on the record. All right, now back to getting a factual basis for this guilty plea. The purpose in that Uniform Superior Court rule is so that the criminal defendant knows that whatever action he did that he may think is a crime, the judge is required to get a factual basis on the record to make sure it was in fact a crime, that all those elements were in fact executed, accomplished. I'm going to give you an example. Wherever you're at, whatever person is near to you here in Georgia, if you ask that person, if you're passed out drunk in a car with a key in the ignition, can they give you a DUI? 9 out of 10 people are going to tell you yes they can, because that's just the word that spreads around Georgia. I've heard it all my life. You got the keys in the ignition, you're going to get a DUI if you passed out in that car, sleeping in that car. But it's just not so. Let's say, for example, you're in a bar and you knock back 3 or 4 shots of tequila. That's enough to give you a DUI any day of the week. and you head on down the road, you get a phone call, gotta go. You're going down the road, and all of a sudden that tequila hits you, and you say, whoa, I gotta stop here. I can't be going down the road like this. You pull off in that Walmart shopping center parking lot where you just come up on, and you let the seat back and you go to sleep. Like after you got the keys in the ignition. Cop comes up and pecks on the window and he wants to give you a DUI. He may give you a DUI. He may arrest you for DUI. But once you read the statutes, and once you get yourself a lawyer, that lawyer is going to explain to you, or you're going to understand that when you read that statute, that police officer must have found you operating a moving vehicle. And if you're sitting in that car in a parking lot, you're not DUI. If you're asleep in that car in a parking lot, you're not DUI. You're not in control of a moving vehicle. All right, that's an example why it is necessary that the judge make sure that the elements of the crime are explained to the criminal defendant, and that he asks you, Mr. Dubberly, were you under the influence of alcohol? Yes, Your Honor. Mr. Dubberly, were you in control of a moving vehicle? No, Your Honor, I was asleep in the car. Whoa, wait a minute, we got a problem here. That's the judge's job. So, what we're going to look at first here, we're going to look at the first count of these 7 counts that Mr. Dubberly is convicted of, that he pled guilty to. It's rape of an 8-year-old girl. Testimony was that she was raped at least 4 times, different times. The elements of rape, the state must prove, and the defendant must understand carnal knowledge. Element number 1, that would be the sexual intercourse. Element number 2, force. You must take that sexual intercourse by force. And number 3 is without the consent of the victim. All right, I'm going to just revert to this transcript here. This is the plea hearing transcript. Right here on page 17, the judge, Honorable Charles P. Rose, he says to the court, all right, at this time, Mrs. Dutton, I'm going to ask that you set forth a factual scenario to support the entry of this plea. Now, years ago, the judge did all this, and now they watered down the whole requirement by letting the prosecutor do this. And when the prosecutor does this, the prosecutor slants it in a way that's beneficial to what her end is that she wants to accomplish. That's all I'm going to say on that for now. But the prosecutor then says, yes, Your Honor. The initial disclosure was made to the maternal grandmother in this case. Now, I've got to be careful here because I don't want to disclose this child's name. So, I'm going to slow down from time to time because the names all throughout here, and I've got to tap dance around these names. So, the initial disclosure, meaning when the child first claimed that she'd had a problem with people raping her, was she was staying with the grandmother. The grandmother was babysitting. We all know how it is, you know. We know how parents will leave their children with their grandparents while they're out working for the day. This was the case here, and the district attorney goes on to say, and basically, the child had been seeing on television where the reports were being made about the girl that was missing in Aruba and nobody knew where she was. And right now, the name is escaping me, and the judge straightens her out, pipes in, and lets her know that the girl's name was Holloway. It was that beautiful blonde-headed girl that was on vacation at the Isle of Aruba and went missing. Never did find the gal. So, Mrs. Dutton, the prosecutor, she says, Holloway, right. And she had questioned her grandmother about what would happen with this girl. And, of course, nobody this day knows what happened to Natalie Holloway. So let's stop right there. Let's just stop right there a minute, because here's where everything began. Grandma and this child, this 8-year-old child, they're in Grandma's living room. They're watching television, and now what they're watching, they're either watching something like Jerry Springer, Maury Povich, one of those shows. And they're could have been Dr. Phil, who knows. But anyway, whatever they're watching, this 8-year-old child should not have been watching it. This is a good reason you'll see as to why. So she sees this missing woman, and she starts asking Grandma what happened with this Natalie Holloway. So we don't know what Grandma said because it's not in here. But let me tell you what this district attorney said. I'm going to read this whole thing again now. The district attorney, she says, Holloway, right, Natalie Holloway. And she had questioned her grandmother about what would happen with this girl, and of course, nobody this day knows what happened to Natalie Holloway. And during this discussion, she said, well, some men have been doing some bad things to me too. All right, now let's stop right there again. This 8-year-old child says, well, some men have been doing some bad things to me too. So now we got an idea as to what else Grandma might have been saying to this child. Because when she says what would happen with this girl, as the district attorney is explaining, and because she's being very vague there, because to be vague meets her purpose. She needs to be vague because she wants it to slant a certain way here. So when the child says to Grandma, well, what's happened to this girl? Well, obviously Grandma said something that would cause a reactionary response of, well, some men have been doing some bad things to me too. So Grandma, while she's watching Jerry Springer or Maury Povich, she must have said to this child, well, some men got her and did some bad things. Something to that effect. Otherwise, this child would not have said, well, some men have been doing some bad things to me too. All right, now, we've got the foundation laid of this whole scenario. We got the foundation laid. Grandma has said something to this child that's made this child say, well, some men have been doing some bad things to me too. Been doing it to me and Natalie Holloway. On Aruba. Okay? So when she says, some men have been doing some bad things to me too, well, what's Grandma going to say? She says, they have. Well, what have they been doing to you? And then, of course, the child, she's going to start stumbling. She's going to say, well, I don't know. I don't want to say Grandma. I don't know. Grandma keeps picking, and the child won't say anything because she got to make something up, and she don't know what to say. She don't know what bad things happened to this girl in Aruba. Nobody does, because nobody's found Natalie Holloway. So she's got to start making something up, and she don't know what to make up. So Grandma just keeps picking, and she just keeps picking, and she just keeps picking. And so finally she can't pick nothing out of the girl. So she says, well, did they touch you somewhere? Or did they do this? Or did they do that? And we're getting some positive answers now, because this takes the whole pressure off the child now. She ain't got to create nothing that she don't know nothing about, and Grandma's feeding it to her, and all she's got to do is acknowledge it. And here we go. A runaway train, folks. We're going down the track with it now. So, all of that leads into rape, 7 other charges of sexual abuse against this child, against Mr. Christopher Dubberly. Now, the judge goes on to say, Now I'm going to tell you something right here. I'm going to skip to this part right here because this is the main part I wanted to share with you. And I'm going to tell you this part right here is going to knock your hat right off in the creek. The judge is still getting the factual basis for the guilty plea here. And so the judge says, Judge Rose, he said, was this child examined by a medical doctor? And the prosecutor, Miss Dutton, she says, yes, Your Honor, the child was examined by Leah Bragg, who's in the courtroom here today. She issued a medical report. And what the medical report says is, well, Your Honor, she can actually tell you what's on the report because she is here. And the judge says, Judge Rose, he says, you can just state it. And I'm going to stop right there again a minute. Now I'm going to tell you something. This judge is supposed to run this courtroom, and he's supposed to make sure that all of the facts are sound facts, true facts, reliable facts. And what this judge should be saying is, hand me that report and let me read it, and then you can state it in open court and get it on the record. But no, he just says, you just state it on the record. Now, he must really trust this prosecutor. I'm going to tell you one thing right now. She's not to be trusted. She is not to be trusted. Here's what she says. When the judge says, you can just state it, Assistant District Attorney Sandra Dutton says, okay, Your Honor. At the time of the exam, she basically says that it was normal, that because of that particular area of the child's body being very stretchy and that there had not been any kind of sexual activity going on immediately preceding the exam, that basically there is no physical evidence or injury that could be noted to prove these 4 rapes. We'll read that again. Okay, Your Honor. At the time of the exam, she basically says that it was a normal examination. That because of the particular area of the child's body being very stretchy and that there had not been any kind of sexual activity going on immediately preceding the exam, that basically there was no physical evidence or injury that could be noted. No evidence. But she's been raped 4 times. There ain't no evidence of it. But she's been raped 4 times. Something probably happened. Something probably happened. Because she goes on to say here, however, it could not be ruled out that her findings were consistent with the child's report of sexual activity. I'm going to say that again. However, we don't have no evidence, but it could not be ruled out that her findings were consistent with the child's report of sexual activity, being raped 4 times. How can that woman stand flat-footed in the court and speak those words and expect someone to accept them? And how can Judge Rose accept what this woman just said? If I were Judge Rose, I would say, woman, what in the hell did you just say? There's no evidence, but that's consistent with the child's report that she's been raped 4 times. What kind of gibberish are you speaking? She goes on to say, and indeed, Your Honor, the child, even though this is not on the actual tape, the child has also disclosed that the defendant actually did what she says is have sexual intercourse with her, that he put it inside of her, and that it hurt, and he just pulled her apart. And she said that this act occurred 3 or 4 times. Now, she's not here to testify to that today. We didn't bring her to court. And we don't have it on that 45-minute CD that we recorded of her making a statement. But she said it to me, Your Honor. She told me that. Been raped 4 times. Tore apart. Just tore apart. This grown man having sexual intercourse with this 8-year-old, 80-pound virgin child. Ripped her to pieces. That's what she said about that medical report. That's what this woman, Assistant District Attorney Sandra Dutton, Atlantic Judicial Circuit, Hinesville, Georgia. The woman is not to be trusted. I'm telling you, what this woman has done, she gave false statements of material fact, false statements of material evidence. Not only is that an abomination and a disgrace to the judicial system, it is a crime. It's a crime. It is a criminal act. Ladies and gentlemen, I have got the medical report right here. Now, I'm protecting this child's name. As you can see, I've got a flap over the top of this report. I'm going to be putting this report on this Georgia Court News website, georgiacourtnews.com. You're going to be able to read the pertinent part of this medical examination. There's a lot that this Sandra Dutton, Assistant District Attorney, did not tell Judge Rose. And as I say, it's going to knock your hat right off in the creek. What this, right down the bottom paragraph, I'm going to tell you right now, the hair standing up on my arms. I can't believe what this woman has done to this man. This last paragraph on this medical report right here, the hymen in this child is intact. The hymen is intact. Yet she's been raped 4 times. There's no evidence of it, but something must have happened. Something could have happened now. But clinically, she is a virgin. A clinical virgin, 8 years old, that's been raped 4 times. Now, ladies and gentlemen, we as Christians, we believe in Immaculate Conception, that the Virgin Mary conceived Jesus Christ and gave birth to Jesus Christ through Immaculate Conception. But I'm going to tell you something right here. We're going to draw the line at an immaculate rape. This woman stood in this courtroom and gave false evidence, manufactured evidence, withheld evidence, and this man, Christopher Dubberly, was sent to prison for 40 years. 40 years, ladies and gentlemen. He's been in prison for 13 years. And I'm going to tell you something. 5 years ago is when I met Mr. Dubberly. It's been 5 years. And when he gave me this file, and I read this medical report, I got back in touch with Mr. Dubberly. I said, Mr. Dubberly, I need you to tell me why you pled guilty. And I got that information out of him first. And after he told me why he pled guilty, I said, Mr. Dubberly, do you understand that this medical report says that the hymen in this child is intact? Mr. Dubberly said to me, what is a hymen? So you see, Mr. Dubberly, he didn't understand what a hymen was. He didn't understand that since the hymen was intact, this child is clinically still a virgin. And for whatever reason he pled guilty, it really doesn't matter, because we know for a fact he didn't rape this child 4 times. It's impossible. The answers to the question as to why he pled guilty really don't matter. We know he didn't rape the girl. It's right there. And we know that this prosecutor held back this evidence. We know that. And we know that Judge Rose allowed this prosecutor the opportunity to do this when he has a responsibility, he should have read that report before he allowed that prosecutor to state it on the record in this case. That's what Judge Rose should have done. Now I'm going to say this. This is Georgia Court News. And what we do here at Georgia Court News, we investigate cases like this, and we find cases where the prosecutors, the lawyers, and the judges are operating outside the law. We find cases where they have sent men to prison under the guise of God and law. And we demonstrate what they have done on this program, as we have just demonstrated here. And I'm going to tell you something else. When I find somebody that's doing this, as I've said before, I am looking in your window, and I'm going to find out all about it. And I know a lot more about this case, but we're going to wrap it up here today. Judge Rose, you have a responsibility to get this boy back in this courtroom. You don't have to go by no procedures and wait for him to file something. This boy don't know nothing about filing anything. And you've sent him down the road long enough over nothing. Prosecutor Dutton, I suggest you get to looking at this case. I suggest you get to hopping around and doing something. And this defense attorney, Mr. Gaskin, you've got a big responsibility this client. Why, Mr. Gaskin, did you not read this report? Don't tell me you don't know what a hymen is. I suggest you get this boy back in the courthouse. Now I'm going to tell you something. I've had enough of this case today. And I'm going to the pond.
My own people did it to me. Just 'cause they could, they sold me out. So be with a brother and kin, happened to you, they sold me out. Just